Yes. Manoj, you can start now.
Yeah, I am Manoj Kumar Chaudhary. Welcome you all on behalf of Nani Palkiwala. Today we are at the part 3 of the comparison of BNS versus IPC. Part 2 we have started from the section 126 of offences against human body, and we have gone up to the 245 of a chapter 40, where we have a false evidence and offences against public justice. So today we have Advocate Jayprakash Somani from Supreme Court of India to give light on different comparisons of BNS versus IPC. Over to you, sir.
Thank you. Friends, let me share you the document. Yes. Today I will give some tips of legal practice also. At the end, some tips may be in between also, because continue reading of the sections may be a boring subject. Yes. From next Tuesday, we will start BNSS versus CRPC. We will complete this today with some practical tips of advocacy. That advocacy is of 3 types: trial court advocacy, high court advocacy, and Supreme Court advocacy. Tribunal, AFT, martial law code, or you can say that trial court advocacy. But appellate court, super appellate court, high court, constitutional courts, and Supreme Court is a different in practice. I am practicing Supreme Court, so there are so many videos on YouTube you can watch on Supreme Court jurisdiction, Supreme Court SHB, like that, of mine on my channel. Let me take you on section, yes, 245. BNS section 245, fraudulently suffering decree for sum not due. So earlier section was in IPC 208. BNS section 246, dishonesty making false claim in court. Dishonestly making false claim in court. Earlier section was in IPC 209. 247 of BNS, fraudulently obtaining decree for sum not due. Earlier section was in IPC 210. BNS section 248, false charge of offense made with intent to injure. Earlier section was in IPC 211. Section 249 of BNS, harboring offender. Earlier section was 212 in IPC. BNS section 250, taking gift etc. to screen an offender from punishment. Earlier section was in IPC 213. BNS section 251, offering gift or restoration of property in consideration of screening offender. Earlier section was in IPC 240. BNS 252, taking gift to help to recover stolen property, etc. Earlier section was in IPC 215. BNS section 253, harboring offender who has escaped from custody or whose apprehension has been ordered. Earlier section was in IPC 216. BNS section 254, penalty for harboring robbers or dacoits. Earlier section was in IPC 216A. BNS section 255, public servant disobeying direction of law with intent to save person from punishment or property from forfeiture. Earlier section was in IPC 217. BNS section 256, public servant framing incorrect record or writing with intent to save person from punishment or property from forfeiture. Earlier section was in IPC 218. BNS section 257, public servant in judicial proceedings corruptly making report, etc., contrary to law. Earlier section was in IPC 219. Section 258 of BNS, commitment for trial or confinement by person having authority who knows that he is acting contrary to law. So this section may be come obstacle for any lawyer also, not only police officer but lawyer also, judicial officer also, judicial registry people also. This section may be harmful if purposely, if we are giving commitment for trial or confinement by person having authority who knows that he is acting contrary to law. Earlier section was in IPC 220. Section 259, intentional omission to apprehend on part of public servant bound to apprehend. Earlier section was in IPC 221. Section 260, intentional omission to apprehend on the part of the public servant bound to apprehend person under sentence or lawfully committed. Earlier section was in IPC 222. BNS section 261, escape from confinement or custody negligently suffered by public servant. Corresponding section in IPC was 223. Section 262 of BNS, resistance or obstruction by a person to his lawful apprehension. Earlier section was in IPC 224. BNS section 263, resistance or obstruction to lawful apprehension of a person, another person. Earlier section was in IPC 225. BNS section 264, omission to apprehend or sufferance of escape on part of the public servant in cases not otherwise provided for. Earlier section was in IPC 225A. BNS section 265, resistance or obstruction to lawful apprehension or escape or rescue in cases not otherwise provided for. Earlier section was in IPC 225B. BNS section 266, violation of a condition of remission of punishment. Earlier section was 227 in IPC. BNS section 267, intentional insult or interruption to public servant sitting in judicial proceedings. Earlier section was 228 in IPC. BNS section 268, personation of an assessor. Earlier section was in IPC 229. BNS Section 269, failure by a person released on a bail, bond or bond to appear in court. Earlier section was in IPC 229A. Then one chapter of IPC is seeing here deleted. Chapter 13 of offences related to weight and measures. So these offences may now shifted to Weight and Measurements Act. Under that offences are there. But here they deleted from here. So IPC section 264, 265, 266 and 267 are deleted, which was related to weight and measurement. Now Weight and Measurement Act is a different act. Earlier was also different act, but penal action was in IPC. See chapter 15 of BNS of offences affecting the public health, safety, convenience, decency and morals. Earlier the chapter was 14 in IPC. So there is no much difference in section of BNS versus IPC in this. Little bit 1 or 2 section difference is there. Section 270 of BNS, public nuisance. Its corresponding section was in IPC 268. BNS section 271, negligent act likely to spread infection of deceit, dangerous to life. Its corresponding section was in IPC 269. BNS section 272, malignant act likely to spread infection of the disease, dangerous to life. Negligent have a different section. Malignant act have a different section. So, like spreading infection like diseases which is dangerous to life, like that COVID diseases like. So it should not happen in our country. So this is the law which is given under section of BNS 272. Its earlier section was in IPC 270. BNS section 273, disobedience to quarantine rule. Its corresponding section was in IPC 271. BNS section 274, adulteration of food or drink intended for sale. Its corresponding section was in IPC 272. BNS section 275, sale of noxious food or drink. Its corresponding section was in IPC 273. BNS section 276, adulteration of drugs. Its corresponding section was in IPC 274. BNS section 277, sale of adulterate drugs. Its corresponding section was in IPC 275. BNS section 278, sale of drug as a different drug or preparation. Corresponding section was in IPC 276. BNS section 279, falling water of public spirit or reservoir. Its corresponding section was in IPC 277. BNS section 280, making atmosphere noxious to health. Its corresponding section was in IPC 278. BNS section 281, rash driving or riding on a public way. Rash driving or riding on public way is also offense. Due to this accident happen, that is a different offense. That may be a homicide, like. But without you are not harming to anybody, but you are rashly driving. Okay, so even though it is offense. Earlier section was 279. Section 282, rash navigation of vessel. Ship, vessel means ship. Rash navigation of vessel. Earlier section was 280 in IPC. BNS section 283, exhibition of false light, mark or vogue. Its earlier section was 281 of IPC. BNS section 284, conveying person by water for hire in unsafe or overloaded vessel. Its corresponding section was 282. BNS section 285, danger or obstruction in public way or line of navigation. Its corresponding section was in IPC 283. BNS section 286, negligent conduct with respect to poisonous substance. Its corresponding section was in IPC 284. BNS section 287, negligent conduct with respect to fire or combustible matter. Its corresponding section was in IPC 285. BNS section 288, negligent conduct with respect to explosive substance. Earlier section was in respect to fire. Negligent conduct with respect to fire. But now 288 is negligent conduct with respect to the explosive substance. Its corresponding section was in IPC 286. BNS section 289, negligent conduct with respect to machinery. Its corresponding section was in IPC 287. BNS section 290, negligent conduct with respect to pulling down, repairing or constructing buildings, etc. Its negligence section was in IPC 288. BNS section 291, negligent conduct with respect to animal. Its corresponding section in IPC was 289. BNS section 291, punishment for public nuisance in cases not otherwise provided for. BNS section, IP section was earlier 290. BNS section 293, continuance of nuisance after injunction to discontinue. Its earlier section was in IPC 291. BNS section 294, sells, etc. for obscene books, etc. Its corresponding section was in IPC 292. Immoral books, which are immoral, which are banned, such type of books sell. You can call them obscene books. BNS section 295, sale, etc. of obscene object to child. Its earlier section was in IPC 293. BNS section 296, Absence Act and Songs. Its corresponding section was in IPC 294. BNS section 297, keeping lottery office without permission. With permission, that is different. But without permission, without license, if you are running lottery office, matka, like matka in Maharashtra, there are matka. It is some type of lottery, but illegal lottery. So they are coming under this section. 297, keeping lottery office. Its corresponding section was in IPC 294A. Then chapter 16 of offences related to religion. Its earlier section, chapter was 15. BNS section 298, injuring or defiling place of worship with intent to insult religion of any class. So somebody is throwing the piece of meat in the temple. So such type of act are coming under this. Injuring or defiling place of worship with intent to insult religion of any class. It earlier section was in IPC 295. Section 299 of BNS, deliberate and malicious act intended to outrage religious feelings of any class by insulting its religion or religious benefit. Its corresponding section was in IPC 295A. BNS section 300, disturbing religious assembly. Its corresponding section was in IPC 296. BNS section 301, trespassing on burial places, etc. Its corresponding section was in IPC 297. BNS section 302, uttering word, etc. with the deliberate intent to wound religious feeling of any person. So see the BNS section 302. Earlier this 302 was for murder, but now this 302 was in BSN, uttering word, etc. with deliberate intent to wound religious feeling of any person. Its earlier section was 298 in IPC. Friends, with this Nani Palikiwala National Law Club, we are running one good project that is called Legal Camp, Legal Guidance, Free Legal Guidance Camp. So, for Supreme Court matter specifically, people are not getting proper guidance. Not getting proper guidance, and when they are approaching some lawyer, so lawyer's guidance, lawyer's meeting charges are very heavy. Some are taking 25,000, some are taking 50,000, some may take 1 lakh rupees also. That it depend upon their brand. I am not putting any negative remarks of successful or eminent senior counsels who are my friend, all senior counsel in Supreme Court of India. We are together, so our profession is together, but maybe different opinion, different, and people who are far away from Delhi are little bit frightened, little bit threatened कि Supreme Court में बहुत पैसा लगता है, Supreme Court में पैसे वाले नहीं जाना चाहिए ऐसा. Some myths are there in the society. So everybody should get the chance to ask query, ask any difficulty related to the Supreme Court matter specifically, because I am practicing, my team is practicing Supreme Court, so we can guide about Supreme Court. Earlier I was practicing in High Court. Before that also I was practicing in District Court. But now I cannot do the guidance on High Court because I left High Court since last 7 years. And after every 2 years, court's entire system is changing. So it is always better to ask any query about that matter, in which court that matter is. Suppose that High Court level matter. So ask that query to a High Court lawyer who is practicing there. Practicing is very important. That person should be practiced there. So on coming Thursday at 5 p.m, we are conducting through Nani Palikiwala National Law Club free legal guidance camp for Supreme Court matters, and that post you will get, and to whom it is relevant, you can send them. You can send them to businessman, you can send them to any persons who know, his matter may be in trial court, he may be in high court. So they can ask. And that is free legal guidance camp. And through Zoom link. We will not give the link directly. We will give one link of that particular WhatsApp group. And people are coming there. And then on Thursday at near about 4 p.m. we'll give them link. And again, before 5 minutes earlier, again we will give that link. And through that link, people can join 1 hour only there. I'm there, 5 to 6. People are coming there. People will ask me, and I will, whatever little knowledge I have with the grace of Lord Krishna, I will share that knowledge with them. Any matter, with the grace of Lord Krishna, I am handling in Supreme Court service matters, property matters, corporate matters, then army matters, near about taxation matters also, criminal matters also. So with the help of my juniors, 5 AORs in my law firm, 12 juniors, including 5 AORs, I am handling that matter. So whatever little knowledge I have, I will give to them and I will try to satisfy and I will give them. Such type of free legal camp you can organize if you want to organize this through your law school or through your bar council, through your law firm also. If you are practicing in suppose Ludhiana or suppose Chandigarh and you have office there and you want to organize one free legal camp, you can call me on any Sunday also to Chandigarh. I will come to Chandigarh. I will come to nearby city, 4 or 5 hours travel like that. Okay. So I will come. I will guide people. You can organize. You can tie up with the MLA, MPs for that. They will provide you expenses because they have the quota of the expenses. 25,000, 30,000, 50,000. You can tell. You can print some handbills. You can distribute it. Who have these specialization for Supreme Court matter. Those who want guidance related to Supreme Court matters, they are telling their story. Some transfer matters are there. So such type of guidance will be there. And on that group, we will put one video also before starting that free guidance. We'll add our video also, the jurisdiction of Supreme Court, which matter Supreme Court is handling, transfer petition, then SLPs, then writ petitions, then precedent reference matters, then ITAT references like that, governor references, all type of, so many types of Supreme Court matter are handling the matter in Supreme Court. So just for the sake of, if you want to conduct this online, so online also, and if you want to conduct this free legal guidance camp offline at your place, anywhere, so you can talk, you can contact to my PA or you can contact to convener of this Nani Palkiwala, Manoj Kumar. So you can contact them or you can contact to my PA Pooja Rai also. So she can avail my time and according to that, we can arrange at your place. No fees for that for anybody who can contact, who can come, who can ask guidance. No fees for it. This is just a social obligation, okay, to reach with till the people. Next, friends, chapter 17, and earlier was also chapter 17 in IPC of offenses against property. So there is a difference, much difference between sections and theft. In BNS, section 303 is related to theft. Its earlier section was in IPC 378. BNS section 303, 303(1). BNS section 303(2) is related to punishment of theft. Earlier its section was 379. One section recently in BNS added newly which was not in IPC. That is a section 304 of BNS is related to snatching. To snatch the golden chain, like that. Snatching, not golden chain, only snatching of bags, snatching of purses, like that. Section 305 of BNS, theft in a dwelling house or mean of transportation or place of worship. Its earlier section was in IPC 380. Section 306, theft by clerk or servant of property in possession of master. Its earlier section was in IPC 381. Section 307, theft after preparation made for causing death, hurt or restraint in order to committing of theft. Earlier section was 382. Of exhortation. Exhortation means to grab.
Associate Ravi Batra Batra.
To grab, to demand a ransom amount, that is called extortion. Somebody's kidnapping somebody's boy or girl, and they are now demanding some money. That is called extortion. There are so many examples you can give of extortion. So friends, section BNS section 308 is related to extortion. Its earlier section was in IPC 383, extortion. BNS section 308(1), 308(2) is related to punishment for extortion. Earlier section was 384. BNS section 308(3) is related to putting person in fear of injury in order to commit extortion. BNS section 308(4) is related to putting person in fear of death or of grievous hurt in order to commit extortion. Its earlier section was in IPC 387. BNS section 308(5), extortion by putting a person in fear of death or grievous hurt. Its earlier section was in IPC 386. BNS section 308, putting person in fear or accusation of offense in order to commit extortion. Its earlier section was 389 in IPC. BNS section 308(7), extortion by threat of accusation of an offense punishable with death or imprisonment for life, etc. Its corresponding section was in IPC 388. Of robbery and dacoity. BNS section 309, robbery. Its corresponding section was in IPC 390. BNS section 309(1), 2, 3. BNS section 309(4) is related to punishment for robbery. Its earlier section was in IPC 392. BNS section 309(5), attempt to commit robbery. Its earlier section was in IPC 393. BNS section 309(6), voluntary causing hurt in committing robbery. Its earlier section was in IPC 394. BNS section 310, dacoity. Earlier section was dacoity was 391 in IPC. BNS section 310(2), punishment for dacoity. Its earlier section was in BNS in IPC 395. BNS section 310, dacoity with murder. Its earlier section was 396. How much lucky we are, because we are witnessing a change of these laws. You see, IPC was changing after 1860. 1860. Now we are in 2024. So grandfathers. So 3-4 generation have used only IPC. For maybe 5 or 6 generations. But we are witness of this change of law. But we have to face some headache also. When you are filing appeal, that time you have to show them new section also, and as well as corresponding its earlier section also. So this is a headache to judiciary also. While giving the decision, they have to club all latest section and earlier section, because matter was filed in trial court before 1st July 2020, and matter is coming to appellate court and after 1st July. So that will happen. Whenever there is a change, so we have to give some time to get used to do that change. Like app also, suppose we are using bank app, but sometimes bank app they are changing their formats. They are coming with very good features also, but we are now facing some problem from issues to operate the app, bank app, when the bank app changes that app, like that. So always when there is a change, public is not ready to accept that change easy. Next, BNS section 310(5), assembling for purpose of committing dacoity. Its earlier section was 402 in IPC. BNS section 310(6), punishment for belonging to gang of dacoit. Its earlier section was in IPC 400. BNS section 311, robbery or dacoity with attempt to cause a death or grievous hurt. Its earlier section was 397. BNS section 312, attempt to commit robbery or dacoity when armed with deadly weapon. Its earlier section was in IPC 398. BNS section 313, punishment for belonging to gang of robbers, dacoit, etc. Earlier section was in IPC 401. Of criminal misappropriation of property. BNS section 314, dishonest misappropriation of property. Its earlier section was in IPC 403. BNS section 315, dishonest misappropriation of property possessed by deceased person at the time of his death. Its earlier section was in IPC 404. Of criminal breach of trust. BNS section 316, criminal breach of trust. Its corresponding section was in IPC 405. BNS section 316(1), BNS section 316(2) is related to punishment for criminal breach of trust. BNS section 316(3) is related to criminal breach of trust by carrier, etc. Its earlier section was in IPC 407. BNS section 316(4), criminal breach of trust by clerk or servant. Its corresponding section was 408 in IPC. BNS section 316(5), criminal breach of trust by public servant or by banker, merchant or agent. Its earlier section was 409. Of receiving stolen property. BNS section 317, stolen property. Its earlier section was in IPC 410. BNS section 317 1, BNS section 317 2, dishonestly receiving stolen property. Its earlier section was in IPC 411. BNS section 317 3, dishonestly receiving property stolen in the commission of dacoity. Its earlier section was in IPC 412. BNS section 317 4, habitually dealing in stolen property. Its earlier section was 413. BNS section 317 5, assisting in concealment of stolen property. So see, all stolen property related section in BNS they have taken in 317, and they have marked it 317 1, 317 2, 373, 374. This is the beauty of this law. Only we have to keep in the mind 317. But what was in IPC 340, 410, 411, 412, 413 and 414. All these 5 sections are related to stolen property. Now section only 370 is related to stolen property, but different classification is given in subsection. Cheating. In BNS section 318, cheating. Its corresponding section was 415 in IPC. BNS section 318(2), punishment for cheating. Its corresponding section was in IPC 417. BNS section 318(3), cheating with knowledge that wrongful loss may ensue to person whose interest offender is bound to protect. Its earlier section was in IPC 418. BNS section 318(4), cheating and dishonestly inducing delivery of property. Its corresponding section was 420 in IPC. Cheating by personation. Cheating by personation. In BNS, this section is 319(1) and 319(2). 319(1) is cheating by personation. Earlier section was 416, and 319(2), punishment for cheating by personation. Its earlier section was 419. Fraudulent deed and dispositions of property. Fraudulent deeds and disposition of property. BNS section 320, dishonest or fraudulent removal or concealment of property to prevent distribution among creditors. Its corresponding section was in IPC 421. BNS section 321, dishonestly or fraudulently preventing debt being available for creditors. Its corresponding section was in IPC 422. BNS section 322, dishonest or fraudulent execution of deed of transfer containing false statement of consideration. Its corresponding section was 423. BNS section 323, dishonest or fraudulent removal or concealment of property. Its corresponding section was 424. BNS section 324, mischief. Its corresponding section was in IPC 425. BNS section 324.1, BNS section 324.2, punishment for mischief. Its earlier section was in IPC 426. There is a new one section 324.3, new subsection in BNS. BNS section 324.4, mischief causing damage to the amount of 50 rupees. BNS section 324.5, new subsection. BNS section 324.6, mischief committed after preparation made for causing death or hurt. Its corresponding section was in IPC 440. BNS section 325, mischief by killing or maiming animals. Its corresponding section was in IPC 428. BNS section 326, mischief by injury, inundation, fire or explosive substance. Its corresponding section was in IPC 430. BNS section 326, BNS section 326B, mischief by injury to public road, bridge, river or channel. Its corresponding section was in IPC 431. Those who are digging the road and they are disturbing road, bridges by digging such type of, so we can put such type of section FIR against them. So in a night, there is very prompt and proper system in Pune, Mumbai, in that cities. So when you are digging pipeline for private, for your purpose, or null connection like tap connection, water connection like that time you tag that line and immediately you repair that within a night. You tag it night, within a night you can. That rule is also available in our Delhi, but people are not following. So we can impose such type of section on them. BNS section 326C, mischief by causing inundation or obstruction of to public drainage attended with damage. BNS section 326D, mischief by destroying, moving or rendering less useful a lighthouse or sick marks. Its corresponding section was in IPC 433. BNS section 326E, mischief by destroying or moving etc. a landmark fixed by public authority. Its corresponding section was 434. Maybe for such type of nonsense mischief may not be fine, may not be fine of imprisonment, but maybe fine of public seva like that. That is new fine system is coming in BNS. ये रोड की सफाई कर लो, वो गली की सफाई 1 महीना तक करो, like that court will give the order. That is good, very good moment. Then BNS section 326. Uh, 326F, mischief by fire or explosive substance with intent to cause damage to amount of 100 or 10 rupees. In case of agriculture products, 10 rupees. Its corresponding section was in IPC 435. In BNS section 326G, mischief by fire or explosive substance with intent to destroy house. Its corresponding section was 436. BNS section 327, mischief with intent to destroy or make unsafe a rail, aircraft, decayed vessel, or one of 20 tons burden. Earlier section was in IPC 437. BNS section 327(1), BNS section 327(2) is related to punishment for the mischief described in above section. Its corresponding section was in IPC 438. BNS section 328, punishment for intentionally running vessel around a shore with intent to commit theft. Its corresponding section was in IPC 439. Now, criminal trespass. BNS section 329, criminal trespass or house trespass. Its corresponding section was in IPC 441. BNS section 329(2), house trespass. Its corresponding section was in IPC 442. BNS section 329(3), punishment for criminal trespass. Its corresponding section was in IPC 447. BNS section 329(4), punishment for house trespass. Its corresponding section was in IPC 448. BNS section 330, house trespass and house breaking. Its corresponding section was 443, lurking house trespass. BNS section 331. IPC 1 section 444, lurking house trespass by night. It is deleted now. House breaking, this given in BNS section 332, house breaking. Its corresponding section was earlier 445. And house breaking by night, it is deleted now. It means not that in night, if you are making house breaking, then it is now deleted from BNS. No, that they have covered in above definition. House breaking, you break house at daytime or midnight also, or evening also, or morning also. There is no classification. House breaking is house breaking. So that they have merged in one section. BNS section 331, punishment for house trespass or house breaking. Its corresponding section was 453. BNS section 331(2), punishment for lurking house trespass or house breaking by night. Its corresponding section was 456. BNS section 331, lurking house trespass or house breaking in order to commit offense punishable with imprisonment. Its corresponding section was 454 of IPC. BNS section 331(4), lurking house trespass or house breaking by night in order to commit offense punishable with imprisonment. BNS section 331(5), lurking house trespass or house breaking after preparation for hurt, assault or wrongful restraint. Its corresponding section was in IPC 455. BNS section 331(6), lurking house trespass or house breaking by night after preparation of hurt, assault or wrongful restraint, its corresponding section was in IPC 458. BNS section 331(7), grievous hurt caused, waste, committing, lurking, house trespass or housebreaking. Its corresponding section was in IPC 459. BNS section 331(8). Pulling बढ़ा दो. BNS section 331(8), all persons jointly concerned in lurking, house trespass or housebreaking by night punishable where death or grievous hurt caused by one of them. Its earlier section was in IPC 460. BNS section 332, house trespass in order to commit offense. IPC's earlier section was 449. BNS section 332A, BNS section 332B, house trespass in order to commit offense punishable with imprisonment for life. Its earlier section was in IPC 450. BNS section 332C, house trespass in order to commit offense punishable with imprisonment. BNS section 333, house trespass after preparation of hurt, assault or wrongful restraint. Its IPC section was 452. BNS section 334, dishonestly breaking open receptacle containing property. Its corresponding section was in IPC 461. BNS section 334(1), BNS section 334(2), punishment for same offense when committed by a person entrusted with custody. Its corresponding section was 462 in IPC. Oh, friends, I will complete this total and then I will give you criminal law practice, or related to subject is related to criminal law. So I will tell you some practice of how to draft the matter. Drafting skill I will tell you today, specifically in appellate court, because I am practicing in Supreme Court. So I am not drafting in Supreme Court. My team is drafting. I am arguing counsel. And but without drafting knowledge, you cannot argue. So I have knowledge. I have, once upon a time, we have drafted for our seniors. We have drafted for our clients. But due to the age factor or due to the practice seniority, we have to divert this work to juniors and we have to share amount to them also for drafting like that. So I will tell you, there are mainly four pillars of advocacy. First, quality drafting. Second, quality research. Third, quality argument. And fourth, most important, how to get matters. How you can get matters. Unless and until you know the art how to you get matters, how matters will come with you. Whenever you get the matter from seniors, you will not get much amount. But when you will get matters directly from client to you, that time you can charge handsome bills. Remember that always. When you become senior, also same thing will happen. Whatever you are giving to junior, you are giving junior to his level, drafting like that. 4,000, 5,000, okay. This case drafting 4,000, 5,000. Okay. Some group matters are there, bigger matter there, maybe more than 5,000. Property matter, near about 4,500 to 5,000. Like that. But that junior can earn handsome amount earning, which you are earning now, only that time when he get the strength of this fourth pillar of advocacy. So that is most important. Today, I will explain only one pillar, how to draft, quality drafting. I will focus on that at the end of this session. आखिरी तक बैठा ना तो फिर तुझे चॉकलेट मिलेगा, like that. Yeah, your parents are regularly have done these things, had done these things while in your childhood, like that. You can consider me as your legal parent. But some people are very sincere, very sincere. When they start to end, they are attending properly. Because they are very sincere in always reading. Reading, watching, continue. You should be in law field. When you are a lawyer now, continue should you like me. I'm not admiring myself. Just I am telling my habit. Early in the morning when I wake up, then I watching TV. After basic press up like that. And then I'm doing my exercise by watching any law video, law related. So by morning start with law. I'm going to toilet on sitting on commode also. I have law book in my hand because I'm from Bombay, and we have the time not to waste a single minute in life. So just this is just a general explanation, not related to quality drafting. I will tell you what is quality drafting, how to draft the matter, and to whom we should draft the matter for getting 4,000, 5,000 rupees. What exactly answer? I will tell you at the end of the session. Pooja, whatever important and other talks like legal camp, I have already talked few minutes, an hour back or an half hour back. Now whatever I'm talking after that. So if you think this is very important, and if you want to cut that part and put separately on YouTube, that is also good. Nice. You can put separate on quality drafting, quality research, quality argument, and then quality, how to get the matters. Friends, chapter 18 of offences related to document and to property marks. Its earlier chapter was also same, 18 in IPC. In BNS section 335, making a false document. Its earlier section was in IPC 464. In BNS section 336, forgery. Earlier section was in IPC 463. BNS section 336(1), BNS section 336(2), punishment for forgery. Earlier section was punishment for forgery 465. BNS section 336(3), forgery for purpose of cheating. Its earlier section was in IPC 468. BNS section 336(4) is related to forgery for the purpose of harmful reputation. Its earlier section was in IPC 469. BNS section 337, forgery of record of court or of public registered, etc. Its corresponding section was in IPC 466. BNS section 338, forgery of valuable security, will, etc. Its corresponding section was in IPC 467. BNS section 339, having possession of document described in section 337 or section 338, knowingly it to be forged and intending to use it as a genuine. Its corresponding section was in IPC 474. BNS section 340, forged document or electronic record and using it as genuine. Its corresponding section was in IPC 470, forged document or electronic record. BNS section 341, 342, using as a genuine forged document or electronic record. Its corresponding section was in IPC 471. BNS section 341, making or possessing counterfeit seal, etc., with intent to commit forgery, punishable under section 338. Its corresponding section was in IPC 472. BNS section 341(1), BNS section 342(2), making or possessing counterfeit seal, etc., with intent to commit forgery, punishable otherwise. Its earlier section was in IPC 473. This 341(3) is a new subsection. 341(4) is also new subsection. 342, counterfeiting device or mark used for. Counterfeiting means duplicate karna, to make it duplicate. To make it duplicate, you can say copy karna, or with fraudulent intent, or with cheating intent, or with some dishonest intent. You are counterfeiting notes or with criminal intention. If you are taking the color copy of that note and you are giving or playing to the children, that will not offense. But you are using that in currency with fraudulent intent, that is offense. That is counterfeit. So, BNS section 342, we already completed. Counterfeiting device or marks used for the authentic document other than those described in above section. BNS section 343, fraudulent cancellation, destruction, etc. for will, authority to adopt or valuable security. Its corresponding section was 477. BNS section 344, falsification of accounts. Its corresponding section was in IPC 477A. Property marks, property and other marks in IPC. BNS section 345, property marks. Earlier section was in IPC 479 for property marks. BNS section 345, 345(2), using false property marks. Its earlier section was in IPC 481. BNS section 345(3), punishment for using a false property marks. Its earlier section was in IPC 482. BNS section 346, tampering with property marks with intent to cause injury. Its corresponding section was in IPC 489. BNS section 347, counterfeiting of property marks. Its corresponding section was in IPC 483. BNS section 347(1), 347(2), counterfeiting mark with used in a public servant, used by a public servant. Its corresponding section was 484. BNS section 348, making or possession of any instrument for counterfeiting of property marks. Its corresponding section was in IPC 485. BNS section 349, selling goods marks with a counterfeit property marks. Its corresponding section was in IPC 486. BNS section 350, making a false marks upon any receptacle containing goods. Its corresponding section was in IPC 487. BNS section 351, 352, punishment for making use of any such false marks. Earlier section was 488 in IPC. Chapter 19 of criminal intimidation, insult, annoyance, defamation, etc. This is last chapter. It corresponding chapter was in IPC 22nd chapter. In BNS, this chapter is 19. In IPC, chapter was 22. Criminal intimidation, insult, and annoyance. BNS section 351, criminal intimidation. Its corresponding section was in IPC section 503. BNS section 351, 1, 351, 2, 351, 3, punishment for criminal intimidation. BNS section 351, 4, criminal intimidation by an annoyance communication. Section 507, corresponding in IPC. BNS section 352, intentional insult with intent to provoke breach of peace. Its corresponding section was 504, intentional insult with intent to provoke breach of the peace. BNS section 353, statement conducting to public mischief. Its corresponding section was 505. BNS section 354, act caused by inducing person to believe that he will be rendered an object of divine displeasure. Its corresponding section was 508 of IPC. BNS section 355, misconduct in the public by drunken person or defamation. Its corresponding section was section 501, 510. Now we are taking defamation, separate defamation. Its earlier chapter was in IPC 21, and here defamation is they covered in chapter 19 only. Earlier defamation chapter was separate in BNS. Section 356, defamation. Defamation is to tell about somebody false with the criminal intention to defame him, badnami karna kisi ki. Defamation. BNS section 356(1), BNS section 356(2), punishment for defamation. Earlier section was 500. BNS section 356(3), printing or engraving matter known to be a defamatory. Its earlier section was 501. BNS section 356(4), sale of printed or engraved substance containing defamatory matters. Its earlier section was 502. Of breach of contract to attend on and supply warrants to helpless person. Chapter 19 in IPC of the criminal breach of contract of the service. Criminal breach of contract of service. BNS section 357, breach of contract to attend on and supply warrants of helpless person. Its corresponding section was in IPC 491. Chapter 20 is there, repel and saving. So section 358 of BNS is related to repel and saving. This is the last section of BNS. and this is new section. And they have deleted attempt to commit suicide. Earlier, this was very offense 309, attempt to commit suicide. Now, this is not offense attempt to commit suicide, but to motivate somebody to commit suicide, that is offense. Then thug, punishment, etc. 303, 3010, 310 and 311. All these three related to the attempt to commit suicide. So this is the end of BNS versus IPC section-wise comparison. I know that this this is not a very entertainable session because only reading section, but this is very useful in future for you. Whenever you have the leisure time, but not in mood to read something, just relax, play this on YouTube. So many my videos I am watching again and again. I myself am watching again and again. So that are useful for us for memorizing that particular section like that. And for the examination purpose, for judiciary examination or for law examination, it is essential to keep some section memorized. And in legal practice also, regular section, you should have the knowledge of that section. So friends, now we are coming on that point, quality drafting. How to draft quality. So first question is, to whom we should draft? Obviously, answer will be there. For client, we are drafting. But this answer is not complete true. This is half true. We should draft for judges. We should draft in such a way that judges should get your matter clearly. No any ambiguity there. Such type of drafting should be there. And when you are drafting in appellate courts, specifically in High Court and Supreme Court, so which order you are challenging? For example, you are challenging High Court double bench order to Supreme Court, or any NCALT matter into Supreme Court, or AFT matter into Supreme Court, or any statutory appeal to Supreme Court. So first read that impugned judgment carefully. On which point that order goes against your client. Find out that. And what are the proper explanation we have given in High Court, but High Court has not considered that. So from that point, from that area, you can find out the substantial question of laws. Without substantial question of laws, you cannot stand in front of the High Court or Supreme Court. Specifically in Supreme Court. On legal question, you can admit the matter in High Court, but not in Supreme Court. Not so in Supreme Court, there should be a substantial question of laws, which High Court has made error while giving the judgment. So find out that point. And then take for drafting. Format is there. Format everywhere is given. In CPC, there are so many formats of civil plaints, different type of plaints. In CRPC, now BNSS, there are so many formats. In Supreme Court also, there are formats given in Supreme Court rules. You can watch my 2-hour webinar on Supreme Court rules. It is available in on YouTube in Nani Palkiwala series. You can find that. Through you can get the entire Supreme Court rules. So format of drafting, and there is one of my book for there are all near about all AOR examinations, AOR of Supreme Court examination. I have my books on leading cases, on professional ethics, and on drafting also. And now one book is now in process of practice and procedure. So these are 4 subjects for AOR examinations. So friends, in AOR drafting book, all draft which are used in Supreme Court, we have given the drafts for that. So draft format you can get easily of Supreme Court, or you can say High Court also you can get the draft in CPC, CRPC, in any law you will get the draft, format of draft. But putting the material in that draft, that is most important. So synopsis, list of days. Synopsis should contain short summary and highlight point which High Court has not considered. Then support that points with your some case laws. Case laws should not be given only bare case laws. It should be with relevant para of that case laws. If we put relevant para of that case law, now, at the time of argument, it is very easy. And at the time of dictation of judgment, it is very easy for judges. So always draft for the judges and for the benefit of your client. Obviously, we are working for the benefit of our client. Whether our client is offender or not, that is the hands of the judiciary. That is the decision of judiciary. But whatever document, whatever witness statement, whatever prosecution witness statement, whatever defense witness statement, which is useful for the benefit of your client, you have to mention all. Sequentially, chronologically, then list of dates, then format of statutory appeal or format of, this is the pattern of Supreme Court. There are some courses of my recorded courses on my app, Jayprakash Somani app. You will find some recorded courses. You can subscribe that courses. You can read them with proper demo, with proper order, with proper everything. You will find that, and you have the access of that particular video near about 2 years also. Your legal life will definitely change. That is my purpose. So then take the main draft. In main draft, salutation like that, cause title. Okay. And then properly question of laws. Specifically in SLP, question of laws. Then after 2 statutory sections in draft, points, and then grounds. Then interim grounds or interim relief, grounds for interim. Then main prayer, then interim prayer, like that. So ground and question of laws are different. Many times people are converting question of laws into question of law start with whether and ground are start with because or that. No. Question of law start with whether it's correct, ground is started with that or because it is correct. But question law or law are different and grounds are different. Some may be similar, but all question of laws are not a ground and all grounds are not a question of laws. So ground should be different. So your proper ground, proper question of laws are there. And at the time of argument, then you should highlight that point which is very useful to admit your case in apex. Don't start arguing like lower court, trial court, high court. High court argument is different and Supreme Court argument is different. In Supreme Court, judges are come with reading properly that briefs. Not that is art there, that is their art. They are taking some assistant of expert persons also to take the notes on that, maybe. But they are aware about your matter. So when you are starting arguing, you starting the giving the factual matrix, they will interpret it. They will interrupt you and they will tell you, go on page number so and so, and give the explanation of this. And if you are unable to give that explanation, your case will be dismissed. So first, before argument, you should have in your mind what are the weak points of your cases. What are strong point of cases? You know that. You will explain that. But judges will point out on the weakness of your cases. And when you are unable to give the answers of your weaknesses of your case, matter will get dismissed. So drafting is most important thing. When your drafting is a perfect, many times I experienced many times, no need to argument also. On that day, I think, I don't remember exactly date, but 1 month back, when I was visited to Pune to visit my family, my wife, my children are in Pune. They are settled, or they are already settled. I was also settled in Pune, but now I am in Delhi, and I am citizen of Delhi also. My voting card, everything is in Delhi. So 1 month back, I went to Pune, and on that day, one argument was there online, because whenever I am out of Delhi, I used to argue online. Online argue, which argument is better? Online argument is better, or offline argument is better? You can watch video of mine on that point. Separate video is there. So which argument is good? So emergency was there. I'm going to my friend's daughter's marriage. I'm driving, and my junior told me, sir, after 3 attempts, our attempt is coming. Instantly, on the roadside, I parked car. I opened the tab. I started quote, and in car, first sentence, apology, Lordship. I'm arguing from my car. Due to some emergency, I have to travel. They said, where are you traveling? Pune. In which car you are traveling? Like that. But Lordship, may I explain some points? No, Mr. Somani, we have noticed your case. Without any material argument, without any material explanation, they have noticed my case. Notice means they have admitted my case, accepted my case. In SLP, admission appeal, not SLP, in statutory appeal also, admission in my Supreme Court is most important achievement of that law. And without giving any factual practice, without uttering any single question of laws, Lordship is telling me your matter is, I will not dismiss. And but when they have then make some humor also with me to which car you are traveling. This is Tiago car, my wife's car. My wife is family court lawyer in Pune. So they told me, have you paid her rent? Yeah. I have paid some rent, but I will give double rent because matter is noticed now. So this is the just humor. They are also telling, I am not asking such type of question to anybody, but just for the sake of humor. Lordship. What is the meaning of this incident is when your drafting is perfect. My team is very tough. There is the skill of, I'm not only LLB, I am MBA LLB. So I am management graduate also. So I have how to manage the law firm, how to manage the drafting lawyer, how to motivate the drafting lawyer to get the drafting perfect. And I'm always giving, right before giving drafting to any drafting lawyer, I'm giving my audio to them. So what is this pattern? which point I want in drafting, which point you should highlight in drafting, everything I'm doing, and then draft them with properly case laws, with proper para, everything. And then I'm observing that I'm doing some corrections. I'm telling them to do some correction in that, and then final draft I'm sending to the client. And every time, clients only one reaction: excellent drafting, sir. Excellent drafting, sir. So this is the credit of my drafting team, and this is the credit of my Lord Krishna's motivation to me to get drafting in favor of our client. Whether my client is an offender or not, or whether my client is true or false, I don't know. That is the decision of judiciary. I should not get botheration of that. But I should try 200% with the bottom of my heart to put each and everything before the court and to help the court for a proper adjudication. So this is the quality drafting. So friends, in next Nani Palkiwala, our series, I will tell you how to argue the case. Quality argument with some beautiful examples. Okay. Thank you. Thanks for attending. Manoj is there. Manoj, you can unmute yourself. Are you there?
Yeah, thank you very much, sir.
Yes.
Thank you. We can get these comparison everywhere, but the motivation which you have given at the last, that we cannot get anywhere. So that is available only on your video. Thank you very much for the motivational speech, sir. Thanks once again.
Thanks for all the audience for attending this program. Thank you. Thank you very much.
Thanks all participants.